our afternoon's work in the 5th International Forum on Environmental Law. The panel is entitled Arbitration in International Courts, and the moderator is Cristián Delpiano Lira from the Second Environmental Court. In international relations, and as you well said, uh, there will be a ruling shortly. We also have Miss María Teresa Infante. As Philippe, Laurence, and Ximena, she wouldn't require any introduction because we all know who she is. María Teresa is also an attorney from the Chilean University. She has a master's degree from Instituto de Altos Estudios Internacionales and member of the International Human Rights Institute. She was an ambassador from Chile into the Netherlands, as well as Peru, Bolivia, and many other things that can be said of María Teresa. Mr. Philippe Sands. Laurence Boisson is connected, and she has a PhD from International Law from the Geneva Institute. She's a professor at the University of Geneva, and she has written at least 9 books and edited something like 19 books, and more than 200 articles were written by Miss Laurence. We can also say many, many other things about Miss Laurence. Now, making this very quick introduction, I will immediately give the floor to Miss Ximena Fuentes. You have 20 minutes. Thank you for being here with us. You have the floor. Thank you. Thank you, Minister Delpiano. And I thank you for the invitation to be here. To talk about international courts and their contribution to environmental law. I am also extremely happy to share this table with friends, Professor Infante, Professor Sands, and Professor Laurence Boisson de Chazournes Chazournes. They're friends and colleagues, and I'm honored to be here with them. Since I was the first to hold the floor, I will bring sort of an introduction to talk about international courts and their contribution to environmental law. International law. I know that you have been talking this morning about all that has been done in terms of environmental law in different national courts, but in international law there is a something that makes it different to national or domestic law, and this feature is one whereby international law exists in a certain community that does not recognize the central power to legislate for all members of the system, nor are they courts that have a jurisdiction whereby all participants may have access to. That is why it is said that the norms of the system to a great extent depend on what the states that are recipients of the norms may accept as norms. Now, since one cannot go to the courts without the consent of the states, then this intervention will occur in as much as there is that consent. So this brings in a big challenge to the legal system and the creation of norms. We would imagine that there is a certain deficit of the norms that are necessary to rule behavior and conduct. This deficit that exists has made international courts to have more power, perhaps often than the domestic ones, because they are often compelled to go beyond the rules that have been consented by the states. Often they promote certain principles in the international spheres. And I think this is what's happened in environmental law. The states have traditionally resisted the imposition of norms and rules on this matter, especially in relation to the environment. And why? Because these rules may involve responsibility. Its violation could also involve compensation because of damage. Thus, we understand the hesitancy of the states to accept that. A first case that is worth mentioning is one that brings in a principle that was afterwards included by others. That was the first case that was recognized by the International Court of Justice. It doesn't have to do with the environment, but it has to do with the Corfu Strait from 1949. It's interesting because on that occasion, the International Court of Justice stated that there is a rule that the states cannot allow knowingly the use of their territory for action that go against the rights of other states. And it's not that this rule is found in any international treaty. It's being invoked by the court as a ground rule to say that there are obligations of conduct between states to avoid that kind of damage, should avoid damage to other states. In 41, there was another court, an arbitral court in the famous case between USA and Canada on trail smelting arbitration. That court indicated the obligation that the states cannot allow their own territory to be used in causing damage to other territories and even beyond these other states. That rule was then included in Principle 21 of the Stockholm Declaration in 72. So the courts anticipated what the various states decided to have in a non-binding instrument such as Stockholm, whereby Principle 21 states that the states have sovereign rights to exploit their own resources and using their own environmental laws, but that they have the obligation to ensure that the activities conducted within their jurisdiction will not damage the environment of other states or areas with no national jurisdiction. Afterwards, the obligation not to cause damage to other territories as seen from an environmental standpoint that is not causing environmental damage caused a certain discussion on its nature, on whether it was related to due diligence or it had to do with the outcomes. But the conclusion was that it was an obligation in due diligence. Nowadays, the states under the Commission of International Law, most of the obligations are objective. It's enough for a violation to occur for that responsibility to take place, but not so with the environment. I'm talking about due diligence obligations. One question we may pose is, what is the translation of the due diligence obligation? Because it's not that the due diligence obligation is a subjective one in terms of the mental state of the states. No, due diligence obligation is translated into objective, specific obligations. But we must take a look at what they are. The International Court of Justice once more contributed to an important case with the participation as attorney, Professor Laurence, who is here part of this panel. And that was the paper cellulose. There was a case between Argentina and Uruguay. On that occasion, the court helped us to understand how are we going to bring in content to due diligence. One of the things that was said is that if there's a potential damage to be caused to another state's territory, the countries have the obligation to conduct cross-border environmental assessment. Up to those days, we hadn't heard about the obligation of this kind. But the court declared so, and it stated as a fact that if there was a potential creation of damage across border, then that would be the case. Now, on that situation, the court stated that the specific content and the cross-border impact assessment would depend on the domestic legislation. So the court doesn't go beyond in stating what this kind of cross-border assessment should include. That is under discretion of the states. But this was all under the main goal, which is avoiding damage to other states or the territories. There are some courts that have aided in giving more content to this cross-border impact assessment. It's worth mentioning the C Court. Here we have Professor María Teresa Infante, who is a judge at the C Courts. And they were requested an opinion on the responsibility of the states that sponsor activities in the area. We're talking about the seabeds beyond national jurisdiction. And the court here once more states in a consultative opinion that the states must not only cooperate with the authorities on seabeds, sea floor on the implementation of environmental impact assessment, but they must also ensure that the contractor companies that act in the area also must meet the obligation of conducting environmental impact assessment, having in mind not just the impact on that area, but also in other places where there may be an impact. And even further, the Sea Court on that same consultation stated that the states must have their own laws and their own administrative rules. They must all try to get all involved, especially companies, to meet the laws of the sponsor state, the state that is sponsoring the activities in the area. Another important contribution made by the courts is seen in human rights courts. We have recently heard in 2017 of an opinion from the International Court on Human Rights. With that opinion, we see the reinforcement of the obligation to conduct that cross-border environmental impact assessment. In the interstate fields, in case of the International Court of Justice or the Sea Courts, the cross-border evaluation stays under the discretion of the states because of their own legislative powers to see what elements are to be included in that cross-border impact assessment, having in mind that they must prevent damage in other states. But this really falls under the sovereignty of the state through its own laws, whether they be administrative or not. But the opinion of the International Court goes one step ahead, and it brings in the obligation of the states not vis-à-vis the neighboring country as a subject of law, but we see the obligation, cross-border obligation, that has in mind human beings, inhabitants of the other country, as entities that have the right. But how did this did the court come to that conclusion? Because we didn't believe that the cross-border assessment had to do with the rights of other states, but it would really impose an obligation on human rights. But the court does so, and it does so in the following way.
First, the court establishes that there are obligations of the states to protect the human rights of people who are outside the territory. So it is a broad interpretation of the term jurisdiction. Under the Inter-American Convention of Human Rights, as we know, the European Court as well as the Inter-American Court have interpreted that a jurisdiction could go beyond the territory. The territory of the related to the territorial limits of a state. And so if it's within the jurisdiction of a state, then they may have to respond for situations that occur outside the territory. But normally this concept of jurisdiction has been used regarding the control of a particular activity. And the cross-border effects of a particular action carried out within a state, the effects beyond the borders, it could be said that they are outside their control. However, here the court uses the same methodology to finally state that if there are damages beyond the national territory, it is possible to say that they are under their jurisdiction or control. And so, in this way, the court established that the inhabitants of other countries that may be the subject of damage on account of activities carried out within one's own territory are persons that are under the control, under the jurisdiction of the original state of the activity. And so, therefore, not making or not having a cross-border environmental impacts assessment could be constituted as not only a violation of the environmental obligation, but also a violation of the international human rights. And this has a plus as well, because as I was saying, that states, if there is no consent, to resort to a court and give them jurisdiction, then it is not possible to file against another state. But in the inter-American sphere, or Europe as well, those states that have accepted the jurisdiction of the inter-American court, for example, are many, and many of these are cross-border. And so here there is a file that you may resort to by the people who suffer the damages and violation of their rights in order to file against the state, which means that if there is no cross-border environmental impact assessment, this could lead to a court case. And finally, since I have only 3 minutes left, I would also like to say that with regard to the international obligations of states, same as sometimes international courts have driven the rules and helped them to develop with greater strength, also on other occasions, it is the domestic courts that have helped to promote and fill with content certain international obligations. And in particular, I would like to speak of a recent development, I would say. Well, although maybe it's not that recent, but I do believe that this has had greater results recently, and that is litigation in the field of climate change. In the field of climate change, one of the things pointed out are the rights of people that we already exist in the planet, but also of the future generations. And this of the future generations, for quite a long time, I believe, was really a sort of intellectia, because it was not possible to appraise easily what this implied in legal terms, because these are persons who have not yet been born. However, already in international instruments, we had this concern for future generations. Article 3 of the Rio Declaration says that, albeit there is a right to the development of states, also there is an obligation to ensure that the future generations may also develop, and for that we must care for the environment. But future generations, since they do not exist today, they themselves cannot defend their rights. And so initially, international law began responding with trying to award future generations for certain legal representativity, a sort of ombudsman for future generations, a sort of individual who may represent these future generations here and today, now. Or also certain courts, the famous case of the Supreme Court in the Philippines, or the case of the mine of Posa. And when it would seem that they were given a legal entity, because they say that people who have not yet been born already are to be considered. And so today we're beginning to see the matter in a different view. And I think this is very interesting. In particular, I would like to refer to a ruling, a recent one, by the German Constitutional Court, in that, in fact, presented an action against a legislation relative to the reduction of greenhouse gas emissions, saying that the obligation contained there is poor for the purposes of defending future generations. And it is interesting because ultimately the Constitutional Court did partially welcome the request and grounded it on, once again, human rights, thereby indicating that there is an obligation stemming from the European Convention on Human Rights so as to decide today on the basis of the principle of prevention and as a sort of balance in the sense that the obligations to be raised today in terms of limiting the greenhouse gas emissions, the change in our economy based on fossil fuels must result in an equilibrium or a balance of loads that is in line with protecting the human rights of future generations, in the sense that we cannot have a distribution of the burden implied by mitigating our levels of these things, so that future generations may have to do such a great effort that they would not be allowed to develop right now in this world. And this is within the context of this. Thank you very much. Thank you, Ximena, for that extraordinary presentation. And now we will move on to the next presentation by Professor María Teresa Infante. And she also is a judge of the International Court of the Sea, and who will speak to us on the environment and the task of the International Court and the law of the sea. I thank you once again for being with us. Thank you, moderator, and I thank the audience for your interest in following these comments and thoughts. Some thoughts on the work of the court, and the matter has been addressed, and the previous speaker mentioned aspects of the work of the court and how this work is being related to an international jurisdictional system quite intensely. The court is part of a system created by the UN Convention adopted in 1982, and so therefore reflects what was a negotiation at the time, with a great belief at the time that a strong system of international courts would support the efficacy of an international convention. The convention has innovative principles. I would like to, among others, mention that it does not allow reservation, but in terms of courts, the convention did have to consider a plural reality at international level, and so therefore states do have the right to choose. And some states can be party, and others, if they decide not to, so they react specifically against these resolutions. And by defect, when there is no agreement among states, it is arbitration. So the convention is generally being applied or simultaneously or successively by the International Court of the Rights of the Sea, either through arbitration, by virtue of the convention, that could have special rules, and the third parties have so foreseen. And so this convention is an instrument that is procedural in nature, but also substantive, and determines obligations, recognizes rights, but relativizes pretensions in legal terms and also creates rules that states may or must develop either at the forum of the convention as such or in specialized bodies. We're going to move ahead a bit and say the following. And so the court is located within the system of dispute settlement. Certain things are excluded either by the convention or the action of the states, which leads to a tremendous discussion in terms of preliminary discussions of the first few cases. We're not going to refer to this, but the main source applied by the Court of the Sea is the UN Convention on the Rights of the Sea. The convention contains principles, rules, and these developments that have been occurred based on that. It is very, very important with two main agreements with a universal vocation, one of which is not universal and the other does have significantly more presence from the viewpoint of the state where we're based. One is on the marine fishery and the other one is at high seas. But the court may also apply other international agreements for the interpretation or sophistication when they're referring to the goals of the convention, that these be submitted according to the agreement. This is a very interesting provision that leads to extend the sphere of what we could call the the law of the sea applicable by agreed on areas or convened areas, and even this could be a matter of interpretation with regard to whether the convened areas reflect an international custom that has been or that appeared after or in relation to the law of the sea. But the things that could be in line with this are very important individual. And there was also talk of the norms of reference of when the application of the law on the rights of the sea requires mentioning other laws on the same lines. And the Ministry of the Environment, he says that this is very important, everything related to the contamination in other areas. And why not also say it in terms of resources? The court is acting in these years and began operating in 1996 through various pathways. One that you always use is a definitive ruling, but also via provisional measures. This is a very highly dynamic area, and this is a decision by the court, especially when controversial strategies are subsequently going to be subject to difficulties in the doctrinary framework in terms of the implementation of the law, and where the court trades their competence for a right to express their own views in a way that is different to the convention. But it is always important that this is there. There are states that disagree with this, but then they also were in disagreement to obtain an opinion by the court that they were of the opinion that it would be interesting. But other Latin American countries disagreed, and the other continents as well.
Now, we will use our imagination. We may ask, will the court know binding issue related to climate change and the implications for the application of certain norms in sea law, or to stick to the convention, or to be adopted in the application of the law, such as baselines or sea limits? There is an announcement. There are some judges that are getting ready for that, for their own opinion. Others are more skeptical. I am one of those who are waiting for some kind of consultation with the legal consequences at sea levels. And we will see which is the legal means whereby this question is posed to the courts. There are others that are now being debated at UN. We still don't know whether there will be approval or not to that request. In introducing the topic that the Court on the Law of the Sea and other courts admit an assessment because they have contributed to a dynamic interpretation of international law. And this is very, very important. We should know about this. It's not an interpretation that was set in 982. It has a posterior kinds of different developments. Naturally, the court will have to say what will be the content of that norm. Now, the court's task has also given content to the part related to the protection of the sea environment, and that through a focus that is not explicitly part of the convention, but that is part of the court's jurisprudence as a precautionary measure, as a precautionary principle. It's also been said that the obligations on Article number 12 of the conventions are obligations having to do with the behavior. And here you did work on the MOPS case where the court developed the concept of cooperation between the states. But I'm not talking about the results of so many activities, but it's very important to see about the obligation to cooperate that is made explicit in different articles of the convention, the obligation to cooperate that is giving meaning to that obligation to cooperate in terms of law of the sea. Now, the instruments that have permitted the development of these concepts, and even more important, have to do with the temporary opinions and the constructive opinions. And finally, an observation that is a personal opinion of mine. It's been shown that there's no ground for the fact that the court on the sea or arbitrage has affected the unity of international law and have fragmented international law. Some renowned jurists, some judges internationally well known were very critical of what was done by these specialized courts, such as the court on the sea. I will now continue with my presentation to give you some examples. There are cases that have been seen from the standpoint of the court, and in arbitrages coming from the Sea Convention make reference to the extension of the application of the rules on the law of the sea, and also coming from other sources, from common law and conventional ones. And there was a very controversial and interesting case called Sunrise with environmental connotations and others that have to do with the use of media by the coastal state in the release of vessels and that sort of thing. And the arbitrage states that the convention permitted the application of other rules. I will very quickly go through this, and let's take a look at some sources and how they have been applied. The environment, that has a full chapter, chapter 12. And this brings in the dichotomy, the main obligation to preserve, on the other hand, the recognition of the sovereign right. The reconciliation of these two is indeed work that should be in the hands of states, specialized international organizations, and international courts. The obligation to adopt measures to prevent, reduce, and control pollution and contamination are very important because there's a sea policy involved that is included in the convention. The duty not to transfer damage on danger to that may pollute others, and this goes hand in hand as to what Professor Fuentes said and what was behind declarations on the environment from 72 and 92 and others, and the obligation to watch out for the risks of contamination and its effects. These are contemporary obligations, although they come from 1982, but the negotiation comes from the 70s, from the Conference on the Law of Sea. And here we see some principles, the onset of some principles that are developed later on. And that is one whereby the states must watch out for the potential effects of their activities. And here we have a precautionary spirit that is a part of Article 206 of that convention. And now let us take a look at some special problems that have been seen as of the application of these principles. Apparently, this only has to do with waste and pollution, but this is really just a drop on everything else. And the court on the sea, on Toulon, says that and by the way, it was not on pollution nor the protection of the sea, but it stated that the preservation of the living resources of the sea is an element behind the protection and preservation of the sea. This is something very rich because it brings in the possibility of giving rise to new studies and new kinds of complaints. And then there are provisionary measures that were adopted by the court that have that perspective in mind. And here we have the publication of the states, and they must ensure and promote the goal of that protection, and that must be linked to the need of limiting any kind of conduct that in a fishery facility may affect the stock of that tuna that is in vulnerable conditions. Now let us take a look at the environment seen as a common interest, not just the state that is protecting its own resource, but the problems of third parties. We're talking about the development of the interest of, for example, behind the port authorities, and there are many things involved in this. There is a fishing convention that is being applied here. And now let us take a look at other cases that show the same focus. And this has to do with the relationship between the courts and these topics. There naturally are cases of arbitrage. We have the protection of the environment that goes beyond pollution. There's a concept of ecosystem that is now part of the convention. And there's a famous arbitrage on Chagos and then the China Sea as well. I'll have to skip over this and go on into the next slide. Here we have the interpretation behind arbitrage on the South China Sea. It says that even though the ecosystem has not been defined in the convention, still it is internationally accepted, the definition Article 2 on the Convention on Biodiversity. You know this well because I think that the courts have used this. And now we go on into another topic that has to do, well, these are the basic norms and having to do with their dynamic application. Another thing has to do with the duty to cooperate, the obligation to cooperate. And here we have the Mox plant case. And here the International Court on Sea Law. Well, there were problems of competencies, but they stated the areas whereby the states must cooperate. And naturally, with the obligation to meet these obligations, that is, exchanging information, see the risks in the operation, designing measures to prevent and avoid contamination. So there is a basic principle and the relationship between the states and the sea right. And the obligation to cooperate is behind all of this. This is not rhetoric. It has to do with the penetration of the right internally with the international ramifications. A very interesting case that was not solved by the Court on the Law of the Sea was the swordfish at EU and Chile. That was in the year 2000, led to the International Sea Court, and there the two countries stated that they were cooperating, but from different perspectives. For EU, the topic was that Chile was applying unilateral measures and that wanted to be a part of a convention that prevented EU from being a part in the protection of certain resources. And that could not be applied. That's what EU stated, that Chile was trying to apply unilateral measures. And Chile maintained that EU, during those days, it was the European Community, had not complied with its obligations according to the high sea obligations of ensuring the preservation of swordfish in the fishing activities under the European flag. And this was brought to the court. And there was an implicit power of the court. And that was to contain the aspirations of the parties and fostering direct negotiations. Negotiations, as my dear friend ambassador used to say, it's a negotiation that is not fully defined. Naturally, it was written, but leaving some open spaces. And this allowed for coexistence and for negotiation between countries to reach a global agreement, such as the South Pacific Agreement that had to do with Europe, with Chile, and the Chile's decision to adopt unilateral decisions so that the high sea fishing activities had to be informed. Now, there are many other things that I can refer to, but I'm afraid that I don't have that much time. Don't you worry, I will I will talk about the lack of time, yes. Now, we're talking now about the precautionary focus in the court and in posterior arbitrage that was developed after precautionary measures, but as a result of the convention. The obligation to include a precautionary remedy that had been announced in 2011 having to do with the responsibility of the sponsorship state regarding mining activities. Now, this was extended from a practical standpoint to fishing activities and the obligation of the flag state to use its flag when it is acting in the exclusive economic zone belonging to another state. And this can be extrapolated to the high sea flag state as well. And the court refers to the obligation to have due diligence, that is adopting all of the necessary measures to prevent risks in the activities of the contractors, and that is the responsibility of the sponsorship state.
And then the court itself in 2015 confirmed this relevant concept. And I will end with a very interesting analysis by Elsa Kelly in the court. She's Argentine and has a very interesting comment on the precautionary approach in the advisory opinion that we've mentioned. And she says that the chamber, who is to comment on the marine funds, the precautionary approach, in the light of an increasing number of international treaties and other instruments reflecting Article 15 of the Rio Declaration, and that gave rise that statement to a trend. And the analysis of that is very lucid in this regard. And she's expressing a feeling. There's another case in the Uruguay River when her country of origin was involved, and these issues were discussed very extensively. And so with this, we end the presentation. And just to conclude, I would like to say that the Convention on the Law of the Sea raises the question of its value as a general law and its relationship with other sources of the law of the sea. It's a relationship that is dynamic, um, evolutionary, and that is not depleted with the decisions of 82, which does not mean that that court is not as imaginative as the ones that we have today. All judges have the right to their own opinions, of course. And then there is a major relationship with the jurisprudence of that court with others in terms of accountability and other conventions that are applicable to social matters. The great relevance of the jurisprudence of the International Court of Justice and arbitral tribunals to interact in this rationale in this particular case in terms of limitations. Because this is a cross-reference to the methods, background, and others. And the specific contributions by the court in this environmental matter, which is a very consistent contribution to the relationship between a sponsoring state and an agent that can be state-owned or a private sector, but acting in the sea, or that may have an impact on the sea. And this is something that has not yet ended. Thank you. Well, thank you very much for that presentation, Maria Teresa. An extraordinary outlook, very complete with regard to task, similar to, say, one of the first environmental treaties under the Convention of the Law of the Sea. There have been, of course, others, but this is the most relevant one there. I would like to remind those in the audience and also those who are connected online that you may ask your questions and write them down on the sheets that you have on your table and hand them in as we go along, and we will do a selection, because I know that there are always very many for the panelists. And so then we're going to move on with the next presentation by Philippe Sands, and who will speak to us on environment and international litigation, personal reflections, International Court of Justice, and Islam. Professor Sands, the floor is yours. Thank you. Thank you very much, and ojalá pudiera hablar en español. Es maravilloso estar en Santiago y estar de vuelta. Temas que iban surgiendo. Yo recuerdo que al inicio de mi carrera, en un debate con un conocido profesor de Derecho Internacional en Brownlee, que escribió un libro muy famoso sobre el derecho internacional, y fue en los años 90.
together on that for a group of 4 Pacific Island states who argued in our written and oral pleadings that the protection of the environment was now part of general international law. And I remember to this day the very strong response we got against that from the United Kingdom, from France, from the United States, from China, from everyone saying it was nonsense to say that the use of nuclear weapons could in any way be regulated by environmental considerations. But we won, and at paragraph 29 of the ICJ advisory opinion is the clear statement that the obligation to protect the environment, in particular in a transboundary context, is now part of the corpus of international law. And Ian Brownlee duly wrote to me and said, yes, he would now put in a chapter on the environment in his book. The chapter was precisely 4 pages long in a book of well over 1,000 pages. And it was really only when James Crawford edited a new edition that we got a proper full and complete chapter. The point that I'm making is that it's in this recent period, as you know, Ximena and Maria Teresa have described, that there have been huge strides forward. And the courts have played an absolutely central role in transforming our consciousness about the place of the environment in the international legal order. That is, I think, very positive news. We go through the various cases, other ones that Ximena didn't mention, the Gabčíkova-Nažmář case, and I think most significantly of all for me, the case of Australia against Japan on whaling in the Antarctic, where the Court of Justice for the very first time, I think, really rolled up its sleeves and got involved in the muck of evidence on whether Japan's alleged research program was genuinely about scientific research. And this was, I think, the very big turning point, at least before the International Court of Justice and the door opened. And Maria Teresa has mentioned also the practice before the Tribunal for the Law of the Sea, or at least I would say under UNCLOS, because it includes Annex 7 arbitrations. I've been very privileged to act in quite a number of the cases that you mentioned, Maria Teresa, and I think that that tribunal and the arbitration tribunals under the Law of the Sea have made a very significant contribution. Curiously, I'm with you entirely. I don't believe in this sense of fragmentation of the international legal order. I actually think that competition between courts is a really good, positive, and healthy thing. And basically, it means that states now have a choice of which type of courts and tribunals they want to go to. And I can tell you from my own experience acting as counsel for many states in these different types of proceedings, we sit and we work out which is the tribunal that is going to give us the most satisfactory outcome. That will include, in some cases, in relation to the environment. And you mentioned now, Maria Teresa, the process that is underway in relation to climate change. I suspect, Ximena, this will reach your inbox too very soon in some way. And of course, the proponents of these ideas, and I'm not involved in pushing these things, although I've been consulted by a number of countries, are frankly looking very closely. Are we going to get a better outcome for the protection of the environment at the International Court of Justice or at the International Tribunal for the Law of the Sea? And there is a sort of equation and a balancing exercise being carried out as you weigh out the options. I've got absolutely no problem with that at all. And if that is how states and other actors want to go, that seems to me to be an incredibly reasonable way to go. So in this context in particular, but perhaps not in so many others, I believe that competition is extremely healthy. It could be said that the creation of the Tribunal for the Law of the Sea is a sort of reflection of a Thatcherite, Reaganite moment of creating a range of different options. So we've seen a huge stage of development in the classical international law issues. But I want to talk about other issues where the scenario is not, I'm afraid, quite as rosy as the one that we have sort of painted. International law remains terribly anthropocentric it has not even begun to fully integrate the real environmental challenges we face. I think we are now increasingly aware, whether it is biodiversity or our oceans or our atmosphere or our climate system, that we are in terrible, terrible trouble. And my own view is that in part, international law has contributed to the problems that we face because it has not faced up fully and properly to the need to adopt a real environmental approach. It's not so much in the interstate cases that I think issues have arisen. The focus that I want to put on is in the field of what is known as investor-state arbitration. In this particular context, you will notice CIDS, we call it the International Center for the Settlement of Investment Disputes. I was counsel in many cases. I then was appointed as an arbitrator, and I stopped acting as counsel because I don't think it is right to be involved in these essentially same types of cases as counsel and as arbitrator. It's called double hatting. I think it's not appropriate. And I have to say that my experience as an arbitrator in the last 10 years in relation to the issue of the willingness of investor-state arbitration to properly integrate environmental concerns into the arbitral process, my sense is that the record is absolutely dismal. And my own feeling is that the system of investor-state arbitration, bilateral investment treaties, energy charter treaties, and other multilateral agreements are actually instruments of ecological catastrophe. Over lunch, I mentioned to the secretary of your tribunal my fear that all of the good work that is being done by your environmental court at the very same time is being undone by the work of essentially privatized arbitral tribunals, in which arbitrators, not all of them, but many of them, with no background and no interest in the public good, social issues, environmental issues, non-profit, non-material financial issues, individuals who can barely spell the word environment, are undoing the ability of states to take reasonable measures to protect their own environment. Now, I've got to be very careful what I say, because I'm sitting on a number of cases, and I don't want to be thrown off those cases. So I'm going to speak in a very restrained way. I can read to you that part of a dissent I wrote recently, because the case has come to an end and the dissent is public. It's a case called Renergy versus Spain. My dissent is dated the 13th of March 2022 or thereabouts. And I'm just going to read you the last paragraph of that dissent. It's a case that concerned renewables and the extent to which Spain had or had not, in altering the rate of return obtained by investors in the face of a major financial crisis and changes in technology which made renewables increasingly cheaper. The majority formed the view that Spain had effectively undermined the legitimate expectations of the investors to a reasonable rate of return. The award is lengthy, the dissent is lengthy. I'll just read out one concluding line. Having explained why I dissent with the majority, I write, in this way, I fear that the majority's approach, which is by no means an isolated one, tends to undermine efforts to allow states to take the actions necessary to address the serious threat of global warming and climate change. By making certain technologies more expensive than they need to be, the approach of the majority offers support for those who see the Energy Charter Treaty as setting out obsolescent rules that reflect a bygone era a legal carbuncle negotiated in an earlier age that will limit efforts truly to transform our energy supply systems and to offer protections to our common environment. Now, I'm very pleased to say that, and I don't take credit for it, but in the months that have passed since that award came down and the dissent came down, the Energy Charter Treaty has entered a process of collapse. It has entered a process of collapse because increasingly states are withdrawing from it. The most recent is Germany just last week, saying that the Energy Charter Treaty undermines the ability of Germany to take reasonable measures to protect its environment and the global environment. This problem is reproduced in relation to bilateral investment treaties. We heard this morning from the judge of the Constitutional Court of Colombia. Again, I have to be extremely careful. I am sitting on two cases involving Colombia's ability to protect its paramos. What I can say publicly is that in one of those cases, Eco Oro versus Colombia, there is an award on the merits. That award is again a 2-to-1 majority. That award and my dissent are public, and the ideals that inspire what I wrote in the Energy Charter Treaty, you will also find reflected in that award. The crucial question today is an instrument such as the Energy Charter Treaty or bilateral investment treaties undermining the ability of reasonable states to take reasonable measures to protect their own environments? And I think the answer to that question is yes. Now, there are honorable exceptions where you'll get a group of arbitrators who will, in my humble opinion, do the right thing. But for the most part, that is not what is happening. And it's not happening not because the rules are inadequate, but because the process of selecting the arbitrators is inadequate. The arbitrators are not publicly appointed. They represent very largely the interests of private individuals as arbitrators, including people like me, and law firms who have an interest, to speak very frankly, in milking the system and keeping the system productive to allow people to go out and sit as arbitrators to be paid very significant sums of money in supposedly dispensing the public good, but very often doing the very opposite. So my simple message here is there is a disconnect between what we have been discussing at ITLOS, at the ICJ, and what's going on in the privatized sector of arbitration in relation to the protection of the rights of investors, in which an imbalance has been created and a disfavor has been created in relation to the rights of states to take reasonable measures. Of course, I'm not saying any measures in any circumstances. And of course, I'm not saying that measures supposedly for environmental benefit should be allowed if they are not genuinely reasonable and intended to protect the environment. But there are now too many cases in which that is not happening, and I think we have a serious problem. When I am asked by states, should we sign any more BITs, my answer is no, under no circumstances, because the system is completely imbalanced, unlike the ITLOS system, unlike the ICJ system. Which brings me to a concluding area. Again, I want to get you to think outside of the box and not just on the classical public international law areas. Some of you will know from my writings, I'm very partial to the area of international criminal law. Since 1945, there have been 4 international crimes: war crimes, crimes against humanity, genocide, and the crime of aggression. And all 4 of those crimes are obviously necessary and have very decent objectives, but they are all essentially anthropocentric. None of them seek to protect our environment. And in that context, I and a group of 11 other colleagues about a year and a half ago were invited to propose a text for a 5th international crime. And that crime is now beginning to move into public consciousness. And it is the crime of ecocide, in which you do not have to demonstrate harm to human beings in order to frame the possibility of the criminal responsibility of an individual in relation to certain harmful acts. The definition we 12 came up with is obviously a first draft. It's a start. I'm very pleased to be able to tell you that last week, the government of Belgium became the first country to take that international definition and to begin the process of incorporating it into its domestic law. And Belgium will become, I think, the first country soon to have a crime of ecocide on its statute books. The French president has committed to doing the same thing. Belgium has gone a step further and has said that it will shortly move to amend the statute of the International Criminal Court to include the possibility of a fifth crime for the protection of the environment, a variation on the theme of ecocide. One of the things that is fascinating to me in this conversation is this is, let's be frank, a generational debate. A lot of the people, myself included, who are involved in these things are old. And we have kids. It was very interesting to me that when a British newspaper announced the composition of a panel to set up an international definition of ecocide, it was the first time, and I think I'm lucky in life and I get to do quite a lot of interesting things, but it was the first time that my three kids, aged sort of 21, 24, 26, all separately sent me a WhatsApp in relation to ecocide and said, "Dad, thank God, finally you're doing something useful." Not entirely in jest. We've got to accept that our generation has let down future generations. You talked about future generations. We've left the generation of our children and some of the people in this room with an extraordinary mess because we are selfish, narcissistic, greedy, and we believe that somehow we can sort it all out and come out on top. And I think the natural order of things, and our scientists are now telling us that is not possible. I've spent much of the last 2 weeks traveling around Chile, and I'm acutely conscious of the challenges that this country and so many other countries now face in relation to environmental issues. Drought, warming, glaciers melting, rivers drying up, and it's only going to go faster and faster. The law generally follows, and that is how it has been in international law. And I think we have to be honest with ourselves. Yes, there have been some positive developments in relation to some of the jurisprudence of the international courts. But the bottom line is that our legal order at the international level remains essentially anthropocentric. It has not fully integrated the real needs to design and apply and enforce rules for the protection of the environment. And unless we start doing that very, very quickly, we will be part of a system in which international law is part of the problem, not part of the solution, and states and other actors are going to have to start moving much faster and much more effectively to deal with what is a real issue and a real problem. I'll stop there.
Very good.
Thank you very much, Professor Sands. And last, but of course not least, we have Professor Laurence Boisson de Chazournes. Thank you very much to connect with us. And now Professor Boisson will share with us some thoughts about contribution of the International Court of Justice to the development of environmental law. Professor Boisson, you have the floor. Thank you very much.
Thank you, dear Minister. It's a pleasure to be with you, even virtually. It's a difficult task for me because I'm the fourth of a panel of, and the three friends have spoken and they have, I think, said a lot of what I wanted to say. So,
Bastante de lo que yo quería traerles. Así que bueno, en pro de la conversación, y yo sé que es muy tarde para ustedes, yo solo diré algunas palabras para luego tener una conversación, una charla con ustedes. Tengo una PPT y voy a usar algunos de mis diapositivas.
I just would like first to say that I'm going to be speaking about the International Court of Justice, but I'm a great admirer of the domestic judges because I think that so far, in terms of contribution to environmental protection, it's the domestic judges who have done the best in terms of pushing the boundaries, as Philippe Sands has said, as mentioned. So, but then I was thinking about this, and I just thought that, but so what has the court said? And in fact, looking at what the court has said, you see that the court has said a lot. And maybe what I'm going to do with you now is just to wonder if the court could not say a bit more about, and for example, Ximena and Philippe have mentioned the advisory opinion of 1996, which was a great moment, and I'd like to highlight, and maybe we can come back to that in the discussion, that in the context of advisory opinions, there is more leeway for courts to say things. So if there is an advisory opinion on climate change, I think it's going to be a great opportunity for the court to refine a bit more what it has said so far in terms of environmental protection. So it spoke about the intergenerational equity. It spoke about the rights of the unborn generations unborn, but could not the court say a bit more about this in terms of equity? And then it spoke about this, the court mentioned this obligation not to cause damage to other states and of areas beyond national control. But we have a very classical understanding of these areas of beyond national control. And I'm wondering what to do with the atmosphere, what to do with climate change, what to do with forests like the Amazonia. All this, is it beyond national jurisdiction, or is it something which is part of the natural systems that we should protect? And it seems to me that there we have to give some more thinking about how to protect the universal environment, the global environment. Now, Philippe mentioned the Gapshikovo Najimaro's decision, the pulp mill's decisions. The court said that sustainable development was there, and in fact there was a need for a balance between economic development and environment. And thinking about what Philippe has said just now about investment arbitration, is it really a balance that we want to achieve, or is it not something else? In fact, is it not that there are certain types of economic development that should be banned, and that we should think about other types of developments? And so it would not really be a balance or reconciliation, but it would be something else. And it is there where I think that sustainable development needs some further thinking about what we mean with sustainable development. Now, with respect to due diligence, Ximena has mentioned it, and I think it's important. The court has emphasized that it's an obligation. But there, once more, how do we use the due diligence with respect to climate change? How do we use due diligence with respect to biodiversity? And especially I'm thinking of, all these actions which are conducted far away from a certain territory, but the state is going to feel the impact. And do we have the rights obligations for dealing with geographical distances and impacts that are felt everywhere in the world when they are caused in Europe or in the United States? So that's another thinking that I'd like to put to stress. The environment impact assessment, we were all pleased with this notion. I think one thing that we should admit, and with Philippe we discussed it a lot, is that the court said it's a general principle of international law, but the court said it has. I can't define it in terms of international law. There is no definition of environment impact assessment at the international level. Is that true? That there is no definition? And is it not true that there are at least an obligation of consultation of the riparian populations, that there should be certain good practices that should be followed? So there too, I think that there is a need to feel a bit more the content of the principle at stake. And then maybe lastly, and this is in line with what, Maria Teresa has said, I think that the court has said something very important in 2018 when it spoke about the notion of ecosystem, and I think that was a step ahead. The Law of the Sea Tribunal had done so already, but there the court said we need to speak in terms of ecosystems when we protect the environment. And the question that I have is that, do we have the right principles for protecting ecosystems? And maybe this is something to be thinking about. So we're going to have a decision on the 1st of December in The Hague, which concerns Chile. And there, I think the court will, I hope the court will address something important, which is exchange of information. And this is something which is related to watercourse. But in fact, when we speak about environmental protection, there is something about what is the information that we need to protect the environment the way we would like to protect it. And there is this divide which is often made between so-called environmental information and so-called economic information. And my view is that very often, and the economic information is going to be crucial for protecting the environment. So exchange of information, notification, there is some further thought to be made about the content of this principle. The court will also speak about sustainable development, and hopefully the court will say a bit more than what it had said so far about sustainable development, because it's not just about the balance, or what the court has named the balance between economic development and environmental protection, but there is also the social development which is at stake, the people, which the protection of the interest of the people living in the region. So we will see. But you see, the court, I think to conclude, the court has said a lot, but there is a need for refinement, and there is also a need for maybe deconstructing what we have constructed in the 90s and early 2000s to be sure that we correct the environment in a way which is adequate to the challenges that we're facing. So with that, I'm going to conclude. Thank you very much.
Thank you very much, Professor Boisson. Respecto de las preguntas, no sé si...
With regard to the questions, well, on account of the time, although we do still have some, because strictly speaking, this table was going to end at 20 to 6, but since we had one more speaker this morning, and also this panel is doing well time-wise. But I would like to ask you a question to each speaker. And then I will ask a second question, which is for everyone. Of those that we have selected. Well, here some more have come in. For Ximena Fuentes, Undersecretary Ximena Fuentes, a question. Well, there are two going in the same direction. One says, and you can maybe, what is the opinion of the Inter-American Court of Human Rights when someone pollutes a body of water and another country shares that water source? And then the cross-border assessment is something that is an obligation for states. How do you believe it is possible to determine a minimum for these rules, and if there is any type of common standard for states? Thank you. Thank you for the questions that are related to cross-border environmental assessment. I have been very much linked to somehow bringing cross-border environmental assessment to the state of Chile, because it was not contemplated specifically under our environmental legislation. However, at least not specifically or clearly. However, I do believe that it is possible to read that the state does have the obligation of doing a cross-border assessment when there are activities within the state of Chile that may have an impact beyond the international borders. And it can be read on account of the mere fact that the definition of the area of influence of a project, it is obvious that this is not going to respect the legal borders. And in reply to the first question, the Inter-American Court, in this consultative opinion or advisory opinion requested by Colombia in 2017, I will give you the number, 23 of 2017. Obviously, they've already read the obligation to do a cross-border environmental assessment under the Inter-American Convention of Human Rights, indicating that the acts under the jurisdiction of a country and that may have an effect beyond the border continue to be acts under the jurisdiction of a country and that violate human rights of populations under their jurisdiction. And that is the interesting thing of the advisory opinion. And so Chile is part of the Inter-American Convention of Human Rights, and so this interpretation by the court is obviously the interpretation that we should follow in the field of application of the convention within this with regard to this specific point. And then what was the next one? And do you believe that it is possible to determine a minimum of this cross-border environmental assessment? Well, the minimum, the least, I would say, is given by certain basic principles. The purpose of cross-border environmental assessment is to determine the possible impact of a human action, a project, beyond the borders. And once those effects have been determined, the obligation is to first mitigate, in the case it is acceptable, a certain degree of effects. And if those effects may be disastrous, then the obligation is to prevent that from happening. And so those are the principles there, and that are also in our legislation. So all of this goes towards preventing damage. So if I'm able to determine that there may be a damage, the conclusion is not to carry out an activity that could be damaging. If I can mitigate it somehow, if I can correct the project, then that will be necessary. But that is the minimum in terms of the outcome of a cross-border environmental assessment. Now, having said that, it is sometimes difficult to do. The most difficult in a cross-border environmental assessment are two things. One, the scientific studies that should be done on the other side of the territory, because obviously there you need the consent of the neighboring state. And two, the other problem with cross-border environmental assessment is monetary, because as a rule, if I'm able to determine that there is an activity that may have a cross-border impact, and I determine that those effects will not be damaging. Nevertheless, you are under the obligation to monitor the activity. And once again, we cannot monitor in the territory of another state without their consent. And so it is essential for a cross-border environmental assessment, the principle of cooperation, as Philippe Sanz said, and notify the other state, talk to the other state, in order to determine what actions in terms of monitoring, mitigation, and so on may be carried out in the neighboring territory. And so that would be my answer. Thank you. Thank you, Ximena. And now, María Teresa Infante, second question, two, in fact. So, do you believe that arbitration clauses in free trade agreements and dispute settlements enable states in developing states to protect the environment? That's one question. And the second question is whether, in your view, what would be the scope of the duty of for cooperation in the case of environmental disputes? Well, first of all, I would refer to the second and then to the first, an area where I'm not representing anyone nor sharing an opinion on anyone's behalf. First of all, this of cooperating would depend on the nature of the issue, but we can say that according to the terms issued by the Tribunal on the Law of the Sea, as well as other courts of justice, the obligation to cooperate is a behavioral obligation. It is an attitude of opening up to exchange information in order to determine the risks of a certain activity and be able to obtain not only information, but at least some type of support for that sort of assessment. Essentially, this has to do with the opening to a work that, well, maybe not joint, but yes, collaborative in certain areas. And that is what we have seen in those cases where there are either certain and proven antecedents that there has been the impact of one state on another, or that the activity may entail such a degree of risk that could have an impact on the goods or the areas of the other state or in areas of the international community. Judge Wolfson said in the case of Wolf Blunt in under the Tribunal on the Law of the Sea that the right to cooperate denotes a very significant change in the general direction of international law. It balances the principle of sovereignty of the states and ensures the interests of the community are taken into account before individual or individualistic interests of states. In practice, what could this mean? It creates, it leads to information, exchanging information, not necessarily not having the consent of the other state, but at least considering in good faith the possibility that the information that I'm giving it to the other state will consider it in good faith. And also, and this is very interesting, that later on was resolved directly between Malaysia and Singapore regarding the policy for the reclamation of land and the advancement of the territory of Singapore. And the Tribunal on the Law of the Sea said that there must be an exchange of information assessing the risks or the effects, and also it says they should establish a group of experts to anticipate what risks the behavior could have for the future. And this is not something that is assured will happen because it is an obligation in terms of behavior or conduct, but it must be taken into account and conducts must be adapted to the spirit and adapt to the risk that that conduct may entail. And regarding the second theme, these do not prohibit nor hinder the adoption of measures and actions in terms of the environment, and what treaties will surely regulate. It cannot be discriminatory nor indicate an indirect privation of rights with other purposes that other than of the environment, in order to prevent a particular operator from operating and place someone else in that sphere and so on. But I'm convinced that environmental themes and public policy in that particular matter, as well as others, are very legitimate in an atmosphere of free trade.
What we try to avoid are discriminatory policies and abusive policies against a certain operator. Very well. Thank you, Professor Infante. I myself will take the liberty of asking Professor Laurence Boisson, because Professor Philippe, there are two questions addressed to you. I will make you one, and the others will be open to the rest of the panel. No, I won't answer. You are the protagonist, certainly. Professor Boisson, can you hear this interpretation into English? Can you hear me? Yes, fine. So the question will be posed in Spanish. Do you believe that the internal jurisdiction of each country is an obstacle for the application of the principles of international environmental law in terms of international dispute settlement?
I don't know if I well understood the question, because it was a translation. So that was, but what was it? It was about the.
Maybe I can make the question in English, but maybe it's very if in your thought if the internal jurisdiction is an obstacle for the application of international environmental principles in the context of international dispute resolution.
Thank you very much, Minister. Yeah. So if I understand well the question, it's about can states be accountable for what they do within their national jurisdiction at the international level through dispute settlement? And I think that one thing that could be said, and we've seen some cases, is that yes, through the concept of due diligence, I think there is something that can be said about the fact that national jurisdiction is going to be looked at and we're going to test if the state has done sufficiently. Environment impact assessment, I think it's another tool for making sure that the state is doing what it should be doing or she should be doing. But it's true that maybe there are issues of environmental protection at the domestic level which are difficult to raise at the international level. Now I'm thinking about biodiversity issues, how to bring biodiversity issues at the international level when it relates to the mismanagement or the bad management of biodiversity at the domestic level. Can another state say that it has a legal, or she has a legal interest to challenge the misbehavings of that state? I don't know. It's interesting because this is something which will be tested also for climate change. Could we see disputes where a state A is going to tell a state B, I'm bringing you before a court or tribunal because you've not done what you should be doing at the domestic level? Open question for me, okay, for the time being. Thank you.
Thank you very much. And para Professor Philippe Sanz.
Professor Philippe, the question, I will make the two questions, but the first one is for you, addressed to you, and the others are to the other members of the panel as well. Professor, what are the elements that are needed, or what should happen to integrate the environmental concerns in the system of the investor state? And the second question, and we also start by your answer, and then we go to the other speakers. What do you believe is the principle of international law that is the most important one, and why? Professor, you have the floor.
Thank you for those questions. I'm absolutely thrilled to see that the clock has magically been reset and given me 6 hours and 7 minutes to respond to the question, which is very, very exciting. Well, that's a wonderful question. How would you begin to do it? I mean, I would deal with the substance and I would deal with the process. I worry that minor tinkering with existing treaties is not the answer. So, for example, right now in relation to the Energy Charter Treaty, there is an effort to, quote unquote, modernize it. I think adding a couple of lines here and there in relation to the protection of the climate system and so on and so forth is manifestly inadequate. I would scrap the entire treaty and start again from scratch, placing the protection of certain environmental and social values absolutely at the beating heart of a new instrument. Time and again, we have seen that minor modifications to existing texts do not achieve a decent outcome. And I'm going to surprise you and tell you that the only thing with which I am in total agreement with what Donald Trump has done while he was president was that he ended investor-state arbitration under the North American Free Trade Agreement, and that was an extremely wise decision. I would do exactly the same thing with the Energy Charter Treaty. Now, if that's not going to happen, and states who represent all of us want to continue with some sort of investor-state arbitration or dispute settlement, fine, we have to respect that. If that's what states want to do. But I would then bring to an immediate end the system of private arbitration and allowing effectively private citizens who have no responsibilities whatsoever for the public good to be appointed to deal with issues that essentially are of pressing public concern. In this regard, I distinguish completely between, on the one hand, commercial arbitration. If private actors want to arbitrate those disputes, that is entirely a matter for them, and I completely respect that. But with investor-state arbitration, you're dealing with the power of the state to act in a particular way. And so I would replace private arbitration with the proposal that has been put forward to create a standing court in which you would have a panel of permanently appointed individuals, people like, Maria Teresa or Ximena or whoever it might be, who then basically develop a degree of expertise in that area and can create a system going forward. I'm not in favor of ending free trade or investment or that kind of stuff. What I'm saying is the system has been completely skewed in one direction, and I don't think there's any point in tinkering with it. It needs a root and branch start from the beginning again to have a better balancing. But I have to say also, I absolutely agree with Laurence that we have now reached the point where we have to ask ourselves whether certain activities should no longer be entitled to protections under international law. And I think we are approaching the point where development of oil and coal and gas is likely to be subject to increasing constraints. And I can see the moment coming pretty soon in which international law says we no longer give you protections in relation to certain types of activities. We're able to do that, for example, in relation to ozone-depleting substances. Well, we did it as an international community, so we have the capacity to do it, but whether or not we actually want to do it is another matter. I'll take 3 seconds to say what is the most important principle of international law: free speech.
Excellent answer. Thank you very much. Ximena, seguimos contigo.
Una cosa en que el derecho internacional
One thing whereby the international law is still indebted to all of us is what is lacking is the creation of an obligation not to cause damage to our own environment. We've been talking about damage to other states or to other areas beyond the national jurisdiction, but if a state destroys its own forest, pollutes its lakes or a certain area and does not come damage to other states and to other areas, why there is no reason to act on the part of other states. I think that here there's something that international law is indebted to all of us. That is why I think that there's a principle of respecting human rights is the most important one, because there, yes, we can change environmental damage into action, whether it be internally, internationally, at interstate courts, or at human rights courts. So I think that is the most important principle. The right to live in a healthy environment is a human right. That is why the recent resolution is so important on the right of humans to live in a healthy environment. Thank you. Wow, it's difficult to talk about the most important principle. I'd say that the content of the Universal Charter on Human Rights are essential. I think these are the sources of all mankind. And between states, the UN Charter, with all its bias and topics, that's the basis of the system of legal order. And as to international and domestic, well, the international system does has obligations for a state internally in terms of the environment. They're pretty strong. We have the Convention on the Protection of Protected Species, water ways, water lands, the species that are on the border between Peru, Ecuador, the Amazons. These are obligations that must be met domestically. Oil pollution, toxic substances, pollution. These treaties are applied in international relations as also within states with their own subjects, with private or public agents. International law has a whole field on this. I am not that much for the relation of states and what they can do in terms of what is done internally. One thing is to act for the states to respond to a common good, such as ozone and climate change. That's one thing. But another thing is that certain internal domestic decisions may be subject to individual action easily. There's an area that is being strongly developed, and we've seen in the case of genocides and demand against Myanmar. There is an interesting possibility of international action because the agreement talks about the common good that is being protected. But when we're talking about other circumstances, for example, a spill in Quintero Bay, oil spill that may be subject of demand from another state, well, there are political elements and of international relations that are quite complicated and it must be considered. Some people will want that, and some groups will strongly advocate for that to happen, but there are others that must see how the state will manage all of this. So I think that the state must internally cater for its own environment.
Finally, Professor Boisson.
Sorry. Yeah, for me, it's going to be, I think it's not the most important, but the most challenging one. I think it's intergenerational equity. Okay, this is that's the one that is giving us some hope, and I hope that we can fulfill this task. Thanks.
Thank you very much. Y así, entonces vamos a dar cierre a esta mesa
And
agradeciéndonos.
so we're going to adjourn this panel, thanking our four panelists, top level. And before handing over to the Master of Ceremonies, I would like to thank everyone who was connected online today, more than 1,000, I'm told, and I think that this is a great turnout. So thank you very much. See you tomorrow. Yes, so it is. And now we're adjourning the first part of this fifth forum. International Forum of Judges for the Environment. We will be meeting again here tomorrow for 9 a.m. sharp when we begin our second day. Good evening and have a